This is the first online lecture of Constitutional Law 2. I'm just going to backtrack for a minute because we haven't met for a while. So we were talking about equal protection, and we were discussing the applicable standards for how that gets employed. And we talked about there being two things you have to sort of consider. One is facial discrimination. That is the law as written, even though it may be absent, some sort of language, right, racial language, that on the face of it, the very sort of approach makes it very clear that it's discriminatory. And so here's an example of it. The court found that a state law establishing districts for the election of representatives to the United States Congress should be deemed to use a racial classification on its face because one bizarrely shaped district could not be explained except in terms of establishing a district where minority race voters would control the outcome of the election. The court did not rule on the question of whether this racial classification was narrowly tailored to a compelling interest, such as remedying proven past discrimination, because that question had not been addressed in the lower courts. So two things. First, the Supreme Court, when they look at these issues, there's a trail, right? There are lower courts, okay, when we're talking about when the court sits as an appellate court. And so if it's not addressed in a lower court, the question becomes, should the Supreme Court pick that issue up, even though it's not been discussed? So here in Shaw versus Reno, and this goes back to 1993, we get an example of how the court might address it. So that's an example what I just read from Shaw versus Reno in 1993. So if a legislative body, whether it's the state or the federal government, writes a particular statute or what have you, could even be a regulation, and it employs it, the question is, the way it is written, is that alone enough to demonstrate that there's been some sort of discrimination, which of course affects equal protection? So besides the way it's written and on the face of it, we've got something else, which is, okay, on the face of it, it's fine. But when they apply the statute or regulation in such a way that it is discriminatory. So even though it wasn't written as such, when you actually go ahead and apply it, or when it is applied, it can be applied in some sort of discriminatory manner. So basically, on the face of the law, the way it's written, it can be discriminatory, but also the way in which it is applied. Now, here's the thing. You have to also look at, the court will look at, whether or not the intention, the motive of the government action or piece of legislation, whether it has a discriminatory purpose or not. Now, how do you get at that? Well, on one hand, what you're looking for is some sort of element of that. Why they write it in the first place? What was their intention? Was their intention legitimate in terms of trying not, or to try to rectify some discrimination, or not to discriminate? So you want to look at whether or not you've got that sort of motive on the part of the government. Remember, if it's discriminatory, that's the government's motive. The court's going to strike that down. So here's an example from Washington versus Davis. This goes back to 1976. So you can see 1993, 1976. We can go back pretty far. And we can see these issues have not been put to rest. They're ongoing. So a police department used results from a written test as a criteria for hiring police officers. So you got a written test, people take it, everyone takes it. Members of identifiable racial minorities consistently got low scores on the test. So why do we think about that for a second? Did they get low scores on the test because in some way the test was biased? In other words, we could expect non-minorities to understand the material because of the way it's presented, or because they're more familiar with it, or not. So the question is, although the test is the same for everyone, will the outcome be fair? Okay, so basically, it's an identifiable racial minority getting these lower scores, although there was no proof, and that's an important issue here. that there was no proof that the test was written, okay, or otherwise employed for the purposes of disadvantaging minority applicants. The intention was not to do that. Remember, there was discriminatory motive. So is there discriminatory motive or is there not? And the court says they don't see in the way the test was written that that motive was there, right? So that should mean that the court would look at that and say there's no motive for this discrimination. We don't see any of it. So we can't justify the claim based on there being some sort of discrimination. So because of the absence of non-statistical proof, okay, why non-statistical proof? Statistics in and of themselves report, in this case, an outcome. It doesn't really explain to us why that outcome was what it was, right? All we know is that just because a group of people, and even a significant number did not do well on the test, doesn't mean that there was a discriminatory motive. For example, you may have to know certain things to do a particular job. You may be able to required to bring certain things together. Okay. Now, it could be that non-minorities might be more familiar with that than, say, minorities would be. But fundamentally, if it's needed to do the job, if they're questioning something on the test to see if a certain skill set's there, while it still may discriminate because of the skill set itself, the bottom line is that there's no motive for doing that, right? There's no intention behind that. So there's no equal protection violation, even though you have statistical evidence. That's not enough, because statistics are going to report, again, just the outcome. We don't know what caused the outcome. And a case such as this is going to have to demonstrate that there was a motive to cause that particular outcome. And in the Washington Davis case, that wasn't there. Another case is McCleskey versus Kemp, and this goes to 1987. So we're jumping from 76 to 87. We looked at 93 before. And here, a statistical study showing that black defendants in capital cases are much more likely to receive the death penalty. So statistically, we know that we get capital offense cases, and we know that minorities, blacks, are more likely to get the death penalty. So let's stop for a second and think about that. Does this mean that there was some sort of discriminatory motive? Without knowing what types of cases we're looking at, murder's murder, for example, yes? We don't know what types. We don't know the backstory. We don't know the facts. It could be that there's something else that explains this, that makes it less likely to show some sort of motive exists. Okay, so that's what we're looking at here. So we go on. Then our white defendants in a state will not itself establish that a particular black defendant was denied equal protection by being sentenced to death for murder in that case. The statistical study is insufficient to prove purposeful discrimination. Okay, so what they're saying is statistics don't matter. You have to explain the motive that caused the statistics. There could be any number of factors, just like with any sort of statistical study. Now, look, we don't necessarily like the idea, right, that that the statistics bear out something happening that maybe we think is somewhat suspicious. But for the court, they're going to need more than just the numbers. The numbers don't give us enough in terms of motive or rationale, right? So here, the discriminatory motive is not present just because the statistics are. Remember that. All right, let's talk about suspect classifications. Now, the thing about suspect classifications is that the court looks at a series of cases over time, and they notice that not divorced from sort of what's going on out there in the real world, but they begin to notice that, well, okay, we're seeing a trend. A lot of cases of a certain type with certain parties involved. Or in the alternative, it could be a cultural thing in terms of what we're all pretty clear about in terms of what's going on out there. People agree. There are news articles and there are conversations and there's discussions in all sorts of venues. Even in the scholarly venues, even on college campuses. There's a ready understanding that, look, there's something going on here. So basically, we look at a few categories, broad categories. One of them, right, is race and national origin. Now, I think we're more familiar with race than we are with national origin. So think of it this way. Remember, government action here is important, and the purpose behind that government action is also important. You have to keep in mind that there's absolutely no value in just saying, well, look, this was the outcome. Right? You can't really do that. Okay, so there has to be a fundamental right involved. If there's not, it's a whole different level, right? What we care about are people's fundamental rights. With the court, when it sees cases on appeal, is most concerned with is the Constitution and people's fundamental rights. If there's no fundamental right at issue, then the court standard gets lowered a bit. We don't want to take away someone's freedom of speech, but it might be more acceptable to us to affect whether someone it qualifies for a specific thing, qualifies to go to a particular college based upon the application process or what have you. Education, is the point here, is education a fundamental right. Now, there's no such thing as an obvious fundamental right except for those things which the Constitution lays out. We know speech is. We know voting is. These things are essential to a free society. Education, not so much so. While we want everyone to have an education, there's no vested overall value in making sure everyone has an education. Now, I don't want to get into discussion about whether or not education has a benefit. It certainly does. That's not what we're talking about here. It's whether or not it's a fundamental right to have that, right? Is it important to the functioning of a democracy? Now, in some ways it is, right? Because you have to be able to understand, issues, things that are going on maybe a more sophisticated level. But in terms of engaging, right, in a democracy, you have a right to vote. You could be voting based on complete ignorance. It doesn't matter. You have a right to vote, and you have a right to vote even though you're fundamentally uninformed. And think about why that is. If we were to require people to know so much X before they can vote, what we have is a slippery slope, right? A literacy test. Do you know enough? That's not a point of a democracy. It's not to make sure all their citizens know what they're supposed to know. That sounds sort of like some other form of government. It's you have a right to engage, whether or not you feel that there is or is not a rationale for your decision. People have a right to their opinions, and opinions don't have to be based in fact. They can just be based in what a person feels. And so we've got a very different situation here when we talk about those sorts of things. The case we want to look at here is Kawamatsu versus United States, 1944. So we visited 1944, 1976, 1987, 1993. This is ongoing. It's ongoing. And while we're working at it, and while we are diminishing the negative impact of, these sorts of discriminatory laws or the like, we're working on that. It's a never-ending, battle, right? Another case is Palomar versus Sudoku, and that's 1984. Here it is. A state could not deny custody of a child from a previous marriage to a white mother merely because her new husband was black. Right? Where the mother was otherwise found to be an appropriate parent. We could if the mother was incompetent or in some way abused the child or the like, we can understand why we might say no, you can't have custody of it. But it's not about the black husband, right? It's about the mother being fit. So racial prejudice against mixed race couples does not justify taking a child from his mother. Just because the woman marries someone of a different race does not disqualify her as a good mother or the person she marries as a good father or vice versa. Race has nothing to do with it. It would be easy if there were always some sort of way of telling that someone was a good person or a bad person, regardless of how we did that. But race is not even close. It has nothing to do with any of this. So fundamentally, we can allow ourselves to consider a case like that as being, acceptable in terms of making decisions about whether people are competent parents or not. If you take a look at school integration, now this has a history that is not stellar. Sometimes the court makes decisions that seem to address the issue, but in every court decision, it's going to have to be applied, right? Okay. It's going to have to be applied, which means in the application, remember? In the application, there could be problems. So even though a court decision or a law seems on the face of it to make perfect sense, or it addresses the issue, the heart of the issue, it doesn't mean it's going to be carried out that way. It doesn't mean that it's going to be effective. So when you look at, school integration, for example, you get a pretty good example of exactly what we're talking about. Discrimination, these kinds of things trying to prevent discrimination could actually enhance, expand discrimination. Sometimes the way it gets applied, you can actually end up doing more harm in terms of reaching your purpose, your goal, than good, because the devil's in the details and in the application of that. So what do you do about segregation? You want to end segregation because you feel that it's fundamentally a violation of equal protection. That seems pretty clear. Question is how you do that, right? You can't correct discrimination by further discriminating. See, and therein lies the rub. That's the problem. How do you address, because you can't legislate into the hearts and minds of people what is not there by nature and nurture, but you can constrain their behavior, right? Now, if you constrain their behavior in a way that just intensifies their nature or their propensity to do certain things, you've really failed in your purpose. In other words, if resolving the problem as you see it is going to end up creating an equal and opposite problem, which may bleed over and back to the original, it's really a flawed decision. And as much as we might like to say, okay, we're trying to do something good and appropriate here, it doesn't really matter. School segregation was a bad thing, but there was an economic component to that. And in America, we don't really like to address economic or class issues. At the core of what America is the promise that anyone can accomplish anything with hard work and the like. There's no there's no inclusion of luck. There's no inclusion of timing or any of that. So at the core of who we are, we believe that, okay, everyone can be anything they want to be. And that's clearly not the case. It doesn't work that way. But then you've got to address the class issue, which means you've got to look at the economics of it. And no one really wants to do that because there's this inbred sort of fear, I think, for most Americans, especially elites, about class distinctions. But they exist, and they're the greatest form of discrimination. They're a legitimate form of discrimination. You could live in my neighborhood so long as you can afford to live here. Okay, seems reasonable, but do certain groups have less access to economic possibilities, and so they're never going to live there, right? The playing field is not level. And so when we look at segregation in schools, for example, not only do we have the complication of education and everyone's right to get one, not only is it further complicated by the economic underpinnings that we don't want to talk, economic and class, But beyond that, trying to fix it by further discrimination is going to be problematic, right? Okay, and so remedying that is not so easy, right? So the question then becomes, again, government motive. Is the government's motive to discriminate? Now, the intention is not to discriminate, right? The intention is to advance the cause of equal equality. That's the goal. That's what we're hoping to do. And there's nothing on the face of any statute written, or even lower court, for the most part, decision that would indicate that the goal here is to discriminate. But the way in which you go about resolving it, which is the practical end of this, is problematic, because you're forcing one group to feel put upon on both sides, simply because of their race. Okay, so when you look at the Supreme Court, and they're upholding certain requirements. In one particular case, in the Adirondack case, that 10% of federal grants for public works be set aside for minority businesses. Okay. Now there's two things with that. 10%. Okay. How do we know 10% is acceptable? And here we said, remember, federal requirement that 10% of federal grants for public works be set aside. Not based on the number of, say, minority businesses. This 10%, it seems arbitrary unless you explain why it's 10%. Why isn't it 5%? Why isn't it 50%? In certain areas, right, the number of minority-run businesses is going to be greater than it would in other areas. So how do you make the determination? How do you decide on that number? 10%, right? All right, so in Adirondack, right, the court reserved judgment on whether a Full-of-Love type program would survive strict scrutiny. Remember, equal protection, strict scrutiny. The government has to have in writing it, right, an essential purpose, right? And the way in which they go about it has to be necessary. You need to demonstrate, right, that this is the way you have to accomplish it, and there's no other way. The court is very much interested in making sure the government, in strict scrutiny cases, when they affect their own ends, they don't do so when there are less draconian measures to do that. The court doesn't want to see the government exercise a power or authority that they don't necessarily have to exercise to accomplish their ends. That's always an issue. All right. Excuse me. All right, so remedying past discrimination where there has been, clear discrimination is something that the court has tried to address, but the court's actions are narrowly tailored, and they have to be narrowly tailored to the specific interest of past discrimination, our interest in resolving that. The court always wants to make sure that there's a narrow path that's been followed here. The likelihood of the government creating a discrimination of some sort, right, goes up when they use means to accomplish their goal that go beyond what they would need in order to accomplish that goal. It's excessive, and you don't need to do that to accomplish your goal. So the court wants to see the government step in and say, well, come before the court and say, okay, look, here's what's going on. Here's why we have to do it this way. Think about the Japanese internment during World War II. Under all normal circumstances, that would be totally unacceptable, right? But why was it acceptable then? Because the nation was under attack. The government was unsure of exactly, who were friendly and who were the enemy. And so I've mentioned this before. It's an overreach, right? Now, the court would allow that because the tenor of the times and the state of affairs was such that the government did something that was extreme in measure, but necessary because there's no other way to really go about accomplishing that goal of separating those that were and were not part of the enemy. Okay, so this idea then in parents, I want to look at this case a little bit more closely. Parents involved in community schools versus Seattle School District number 1. In this case, and this goes to 2007, right? So you get 2 metropolitan school districts, and they sought to assign students to schools to achieve racial balance. Okay, if you think that we're done with that, think about New York City. Think about these specialized high schools, right? Bronx Science is one, and there's a test to get in. The mayor of New York believes that test discriminates and keeps out or bars certain groups, and so wants the test changed. The question then becomes, is the test being changed because there's something discriminatory about the test, or is the test being changed because you want to affect a greater minority population in these sort of schools? Of course, the pushback here is tremendous. Also, we know today there's discrimination against Asian Americans in terms of their applications. There are a lot of them to Ivy League schools, to law school, to medical school. And as a consequence, there is an effort, although sort of not spoken in, outright, to limit that population in the school. Now, under diversity, there's a value to having diversity in the school, right? We want a mix of people. Exposure to people that are not like you is a good thing. So a school may want demographic diversity. And so when you look at backgrounds of people, you might be tempted to say, okay, well, look, we have a lot of this particular group. Suppose it was people wearing hats. We have a lot of people that wear hats. And I'm not trying to trivialize this. I'm trying to make clear what's sort of at work here. So we want people that don't have hats, more of those. Is that acceptable? The answer is probably yes, because hats have nothing to do with a person's identity, right? And that's this was really about, right? It's identity. But suppose schools say we have a lot of applicants from New York. It's a New York school, a lot of applicants from New York trying to go to law school or to a graduate program. And they say we have a lot of people from New York, but no one from Montana. And lo and behold, there are 3 applicants from Montana. Now, is it okay for the school to say, well, we're going to give those seats to 2 of those 3 applicants because they're just as good, they're just as based on all measures, they're the same as the students locally. Well, geographic, identifiers don't really speak to the person's identity. You cannot help your identity, right? You can always move. You want to get in, move to Montana. In fact, you want to go to law school in Montana. It's a good thing to come from New York. Not a lot of New Yorkers want to go to law school or graduate school or medical school in Montana. So I would imagine if you really wanted to go to law school, medical school, or graduate school in Montana and you live in New York, or whoever you are, whatever your particular identities, identity politics, whatever your identities are, the things that describe you, if they're different than the general applicant pool based on demographic concerns, some schools would say, well, we're going to give more weight to this application over that. Okay, so that's based on the demographics of where you live. It doesn't speak to who you are, right? Coming from New York, say even New York City, is not doesn't really say anything about you. I mean, you may want to think it does, that New Yorkers somehow are more in tune, smarter, whatever you want to whatever kind of positive thing you want to lay on top of it, that's fine. But it's really demographic in nature. People from New York have a different point of view. They've been exposed to different things. We'd like to have that on our campus because then our students get the benefit of that, and they see some value in that. So in this particular case, the Seattle schools, again, this goes back to 2007. The Seattle School District, which is the defendant here, implemented a student assignment plan designed to achieve numerically defined racial balance between Seattle's 10 public schools. Now stop and think about that. They're looking for racial balance. Okay, so just take a step back. Can we say that people of different races bring something different to the table? Reasonable. You could have a very wealthy person who's in the minority group, right? And a very poor person who's in a non-minority group. And just because someone is a minority doesn't mean it's discrimination on the face of it. It doesn't mean that somehow they've been disadvantaged. Now, is it likely the case? Perhaps, right? Probably a pretty good bet, but it's not a certainty. It's not a good measure. Never is, for good or ill. However, they had never been found to run racially segregated schools. So the Jefferson County Public Schools in Louisville, Kentucky, right in Louisville, was under a desegregation order from 1975 to 2000, and the order was dissolved in 2001 when a federal court ruled that Louisville, the defendant here, had reached unitary status by largely eliminating the district's earlier racial discrimination. So even under that policy, that attempt at eliminating segregation, the court said, you got there. You basically got there. So after the decree was dissolved, Louisville voluntarily adopted a student assignment plan that required specific minimum and maximum enrollment percentages for black students. Here's the tip-off. When you hear percentage, something's wrong, because you never know what the percentage is. How do you come up with a percentage and say, this number is perfect for accomplishing what we want to do? This number. Any other number wouldn't do, but this number will do. So I'm not saying that that's got to be always the case, but your ears should perk up. You should say, well, why that number? Why not a smaller number? Why not a larger number? All right, parents of students who were denied admission to each school district sued their respective district, alleging, in part, violation of the Equal Protection Clause after the intermediate appellate courts in both cases upheld the assignment plans. The parents petitioned, the plaintiffs here, petitioned the Supreme Court for further review. So here's the issue, which you've probably figured out by now, right? Is racial balance between local high school districts a compelling government interest under the Equal Protection Clause? Court, no. Now think about it again, the issue. Is racial balance between local high school districts a compelling government interest? Remember, compelling. That's the strict scrutiny standard, right? It's got to be compelling, which means it's essential for the government to do for government purposes and to serve the larger democracy. And the court said no. Racial balance between local high school districts is not a compelling government interest under the Equal Protection Clause because both school districts have apportioned government benefits on the basis of race. The applicable standard of review in these cases is strict scrutiny. Remember, strict scrutiny is where the government is almost always going to lose. The court has looked at the case and said, you know what? We don't see a compelling interest here. And we see a fundamental right at stake. So we're going to apply the highest and most difficult standard to meet, for the government to meet. Right? And so Seattle and Louisville must show that their race-based discrimination, first, advances a compelling government interest, through two, means that are narrowly tailored to achieve the intended purpose. And there are the two standards of strict scrutiny, right? Compelling interest, right? And you need actions have to affect an intended purpose, right? And the asserted interest in both Seattle and Louisville reduced to nothing more than a goal of numerical racial balance between districts, schools. This court has consistently found such a purpose illegitimate. You can't use numbers. Okay, so let's take a step back. Why not? Because numbers can discriminate. Let's just say you said 10% of a particular minority group are going to be accepted to a school. How do you know it's not 20% that qualified? that 20% based on normal standards would have gotten in. But you've reached your quota. So you're good. You haven't discriminated. Well, yes, you have. You've used race as a way of limiting the number of people in your school rather than qualifications. So that 10%, as we talked about before, could be way low. It could be high. We don't know. That's why when we start talking about numbers, court almost always rejects it, right? The Bakke case, which we'll get to, if the court recognizes that the decision here is being made solely on race, and a percentage of that race, it's discriminatory by nature. It has to be. Think of this. Suppose I said in my classes, 10% of the people were going to get A's, A pluses, 10% were going to get A's, 10% A minuses, 10% B pluses, 10% B's, and so on and so forth, right? Until we got to 100%. I'm not sure if those numbers add up, to cover the complete, sort of spectrum from A pluses all the way to failing grades. But nevertheless, who says that there are 10% of the class that deserve an A plus, or that 10% deserve a D? The argument often made, and this happens in law school, is that, we're actually grading people relative to one another. Here's the problem with that. Suppose the best exam was really horrible. It wasn't very good at all. But all the other exams were even worse. So are you doing justice to that person that got the A plus when really their exam may have been worth, a B? So that person leaves thinking, I got an A plus in this particular course. I really knew my stuff. Someone else at some other school takes a similar course, different professor, of course, but same course. Or you know what, let's make it the same professor. This professor teaches at 2 law schools. And the professor employs exactly the same methodology. But there, the papers are great. I mean, really good. And it turns out that an A plus there, right, that paper, when compared to an A plus at that other school, difference between night and day. I mean, the paper that came from, the second school absolutely blew out of the water the best paper from the other school. But they both walk out with an A plus. And by the way, I'm not saying that, the second school has got to be one of greater notoriety. It doesn't have to be, right? There's no guarantee that because, it's a well-known graduate program, law program, medical program, that the person that gets an A plus there is far superior to someone who gets an A plus elsewhere. For so many reasons. It's inherently unfair, right? And it's misleading to the students. So, you walk out with a certain GPA. Well, that GPA has really been marked against all the other folks. And their GPAs may seem in line with the other schools, but the quality of work and the extent of their knowledge is very different. Now, I know you can't do this perfectly. I know that, in reading papers, right, you do your best, but there's always a fudge factor. Should this be an A plus? Should it be an A? Should it be a C or a C minus? How do you determine that? It's not a science. It's not like, the number of words really determine it. It's the ideas. And how do you weigh some good ideas against some bad ideas in a paper? If the good ideas are about major things, major particulars, then that would be different than if they weren't major issues. So I can't say, for me at least, when I read a paper, that I can say, I'm absolutely certain that this is what the grade is, down to the number. Remember, that's why we give a range of grades to get a particular letter grade, right? You can get, an 80 to an 83 or whatever it is and get a B minus. You have a 3-point leeway. So these things with numbers are never accurate. Now, can we say that the A plus is probably better at every school than people that receive, D's? It's reasonable. But much beyond that we can't say. So the issue is racial balance between local high school districts, a compelling government interest under the Equal Protection Clause. The answer is no. Racial balance between local high school districts is not a compelling government interest under the Equal Protection. Now we're going to move to part 2 of the lecture. There's no rationale for it in terms of this is where I stopped before and now we're moving on. It's just around 45 minutes, and I figured people could take a bit of a break and come back refreshed and ready to consider the ideas maybe a little bit more fully. All right. Excuse me, I'm losing things here. All right. So here we go. So we're going to move off of the idea of education, although you should be aware of the Parents case, the Greta Bollinger case, Fisher versus University of Texas Austin case. I don't want to get and Ambach versus Norwick. I don't want to keep going on education. So I want to move on now to undocumented aliens in terms of them being a particular group that we have to think of in terms of equal protection. So let me just make a quick aside. The issue today is very contentious, and we're not going to address any of that. What we're interested in is how these things sort of play out for different people in terms of equal protection. So here we talk about undocumented aliens. Now, we use undocumented rather than illegal. Because what makes people legal is being documented. So it's kind of, unnecessary to say illegal aliens. They're undocumented. And now, I don't want to get caught in the way in which we express that. I think the ideas behind it are really important, and that's what we need to focus on. So that's what we're going to focus on. So what about punitive laws against undocumented alien adults? Now, adults are different than children. I think you have to consider that when we talk about adults, there are a couple of things that they have in place that children don't. One, they have more control over what they do and when they do it and how they do it. Children do not, right? And the second thing is that one would assume that adults have a better understanding of processes. How does this process work? What are the steps involved and how should I do that? And so on and so forth. So what we're concerned with are punitive laws against undocumented alien adults, right? The Supreme Court has not held that undocumented aliens are a suspect classification. Remember, suspect classification is an important part of all this, right? In terms of equal protection, we need a suspect class. So the first decision is, are undocumented aliens, adults, we're talking about adults now, are they entitled to equal protection under the law? The court has not dealt with that. The court has not said that they are a suspect class or not. Now, if they are a suspect classification, then it becomes, okay, is this a fundamental right? And then the court makes a decision based on those particular factors. All right. So a state law that denies benefits to or imposes a burden on persons who are in the United States without permission of the federal government. Now, keep in mind, immigration, all of that is a federal, not a state issue. The federal government controls the borders of the country, not the states. Now, that doesn't mean states can't challenge it. It doesn't mean that in many cases this is an unresolved issue, but fundamentally, immigration and naturalization is the purview of the federal government, not the states. All right, so keep that in mind. Thus, a state law that denies benefits or imposes burdens on persons who are in the United States without the permission of the federal government might be upheld under the rational basis test as long as the law was not totally arbitrary. So, basically, we're not going to apply strict scrutiny, not a suspect class, but it might be upheld under one of the lower levels of scrutiny. And that might be the case simply because on a rational basis test, there may be a reason why the state is doing that that advances some cause of the state or what have you. Now, okay, again, economics. No one talks about this. But, there's a lot of people that come into the country and they work, on farms, picking fruit, that sort of thing. And, California, for example, has a very large agricultural industry. It's one of the reasons why water is so important in California. It's a major issue in California because you need water, obviously, for crops. So there, and Florida as well. So what is the impact? And watch how this can kind of, ripple through. The impact of not having workers that would do that work means that you'd get less to market, which means the price of goods would go up for oranges or, peaches, whatever it may be, lettuce, therefore impacting the economic well-being of people who are going to buy those goods because now they're more expensive. That's what we're really looking at. That's a major problem. So you have to wrestle with it. What would we do? California depends, its industries depend upon, using, undocumented workers because of cheaper labor and they're willing to do the work. And if we restrict that, we say California can't do that, then we've got a problem. The problem really is the economics of it. So Republicans and Democrats alike, I'm not saying they turn a blind eye to it, but they certainly say one thing and then accept another, right? And the thing they want to accept is actually the same for both sides. They want the undocumented workers to do the work because it's good for the economy. Is it discriminatory against those undocumented workers? Yes. If you gave everyone, including undocumented workers that came in to work during the season or whatever, they had to get paid the minimum wage across the board, it might be different for those businesses and that would take these undocumented workers in to work. But keep in mind, if you're paying the minimum wage or you're paying more than minimum wage, you're going to raise the price of the goods in the marketplace, which means the average American is going to end up paying more for a head of lettuce. And that has an economic impact. We don't think of it that way. But imagine a whole bunch of, goods, say, just vegetables and fruits, got much more expensive. People stopped buying them. Supply and demand. So in some way, we're all co-conspirators here. It's one of the reasons why when you look at China, willing to use cheap labor to make goods, therefore more profit, it's a smart business model. But at the end of the day, what you've really got, right, is you've got cheaper consumer products, which we're all co-conspirators in. We like them, but you do, increase the wealth elsewhere, and we're not getting into the argument whether that's good, that's bad, or indifferent. The bottom line is that that's an outcome, and you have to recognize that as an outcome and make a determination as to whether or not the outcome is acceptable. There's nothing more. There's nothing more exacting than that. That's the economics of it. Again, in America, we like to take the economics of things and move them aside. Quite honestly, because if we try to fix that, it has far-reaching implications that I don't think anyone really wants to address on many different levels. And so, as a unfortunate outcome, we wrestle with these ideas. People take polar opposite positions, but at the end of the day, they all want the same thing: Democrats, Republicans, and the public. We want a cheap apple. We want a cheaper pair of shoes. Our dollar goes further. So those that have had me in class know that I'm an advocate for economic equality. I think that that's really what it's all about. But we don't really have those discussions in the country. We just don't. They're too hard to resolve, and they have a negative impact on a lot of people, including the undocumented workers. But there again, they're here because they're going to make more here than they would maybe in their home country or whatever. Their home country is war-torn or whatever the case might be. They've made a decision to come here for a reason. And that doesn't mean they're coming here to be on the government dole or what have you. Okay, so they're not a suspect class. What about children? And this gets even dicier for, we talk about undocumented. Look, children that come in on their own, that's a different set of circumstances. Still not a suspect class, but, underneath strict scrutiny. But on a rational basis, they're here without any adults. Let's say that particular one group. They're here without any adults. So what do you do with them? Obviously, they need care. They need, because they're young, they need us to sort of take care of them more, protect them. Then you get those that come in with adults, some of whom are their parents, some of whom are not. And so you have to ferret that out. Again, another complicated issue. But when you get children living apart from parents, and here's what's interesting. The Supreme Court upheld, and this is in Martinez, and this goes back to 1983, upheld a state statute that permitted a school district to deny tuition-free education to any child, whether or not he's a United States citizen, who lived apart from his parent or lawful guardian if the child's presence in the school district was for the quote-unquote primary purpose of attending school in the district. The state does not have to consider such a child to be a bona fide resident of the school district. Now, the key phraseology here in the case is the state does not have to, but the state could. They don't have to, but they could, right? All right, let's move off of suspect classes and equal protection, and let's move on to quasi-suspect classes. Now, quasi-suspect classes is based basically on gender or legitimacy. Classifications based on gender and legitimacy are almost always suspect in some way. This is becoming more complicated as we wrestle with the ideas of gender identity, and try and figure out how we approach that. What is a reasonable way to approach it? And you get the full spectrum, as one might expect, of positions on this. From, there's only two genders, to there's a multitude of genders, to there should be no gender issues at all. So if we look at gender or legitimacy is a word that's gone out that, has gone out the window really a long time ago. It's not something that we need necessarily to almost address, but these are suspect in some way. And now when you look at the government's action based on such classifications, the court's going to apply intermediate standard and strike the action unless it is substantially, this is the standard now for intermediate, substantially related to an important government interest. See the lower standard? Substantially related to an important government interest. Not compelling, right? But important. Meaning that it advances democracy or the state in some way, but it's not necessarily essential for the state's well-being, total well-being, ultimate well-being. Okay. Again, this is like the grade thing. I mean, how do you navigate where those lines are? How do you make the determination that, look, this is exactly falls into a quasi-suspect class. This other falls into a suspect class. These are things the court wrestles with. So there's a couple of cases here, I want you to pay special attention to. I'm going to read examples from several, and I'm going to make a comparison. And then I'll tell you which case I want you to really take a look at, and hopefully it'll be obvious by the time we get there. All right. So intentional discrimination against women, gender. Okay. Gender classifications that intentionally discriminate against women will generally be invalid under the intermediate standard, under that standard, because the government is unable to show the exceedingly pervasive justification, that's quote, right? Exceedingly pervasive justification that is required. So here's two examples. Kirchberg versus Fenstra, and this is not a case that you necessarily have to remember, but it's one that you should consider. A statute giving a husband, as head of the household, the right to unilaterally dispose of property jointly owned with his wife violates equal protection. They equally own it, but the husband can sell it. The wife cannot. Another example. A statute giving preference to males over females to act as administrators of an estate violates equal protection, Reed versus Reed. The case in determining who should serve is not an important interest, who serves as executor. Compare those now, juxtapose them to Gedelig and Aiello, a state law that excluded from state disability insurance benefits quote-unquote disabilities arising from normal pregnancy and childbirth was upheld on a holding that it did not constitute a gender classification and so did not constitute intentional discrimination. Women get pregnant and give birth. Men do not. And so if you say women, excuse me, and this is 1974 example. Women don't necessarily, because they get pregnant, fall into this category. Is it a gender issue? Is it not a gender issue? Okay. Second example here. A state statute granting a hiring preference to veterans was upheld even though the result would be disadvantaging women since those veterans are men. The court found that the purpose of the statute was to help veterans, not to discriminate against women. This is the personal administrator of Massachusetts versus Feeney. Now look, this case goes back to 1979. You see the difference here, right? There was no motive to discriminate. It said veterans. Just because more veterans happen to be men doesn't matter. It's veterans. If there's a woman, right, that is a veteran, then she's entitled. It's veterans, it's not men. If it said men, right, then we'd have an issue. Veterans, we don't. You see, it's, again, the purpose is to help veterans, not, the motive is not to discriminate against women. Now, in the previous case, in, Aiello, you've got a different set of circumstances, right, that basically excluded state disability insurance benefits as disabilities arising from normal pregnancy and childbirth. The word there that's problematic is the disability. It's, whether we want to define childbirth as rendering the mother temporarily or what have you disabled becomes a bit problematic. Okay, so here let's talk about how the government interest has to be, genuine. It can't be trumped up. It has to be genuine. So it has to be done to advance the government interest, to justify categorization on the basis of gender. It has to be genuine. There has to be a rationale for it that we can all accept, right? There has to be some acceptable measure for this, not hypothesized for the purpose of litigation. The court, as you know from earlier lectures, does not like dealing with hypotheticals. There has to be an actual case. Okay, so the government justification relying on overbroad generalizations about males and females that will create and perpetuate the legal, social, and economic inferiority of women. This is the United States versus Virginia, right? So here's an example, and this is United States versus Virginia, and the following. When the state military school's policy of admitting only men was challenged, the state justified the policy claiming that, one, offering a diversity of educational approaches within the state, some schools have men only, some have women only, and some have both, yields important educational benefits, and to females generally would not be able to meet the school's physical requirements and would not do well under the school's adversative approach to education. The Supreme Court found these arguments unavailing. Right? There was no evidence that the single-sex school in question was established or had been maintained with a view towards fostering a diversity of educational opportunities, and there was some evidence that some women could meet the school's physical requirements and thrive under the school's adversative approach. In other words, there was no rationale for just men. If even one woman can meet the standard, then that woman should not be discriminated against. Right? So, we've come to realize, I think, more and more in all aspects of our experience in America, that gender really plays a very small role in most things. Again, women get pregnant, men don't. There is something about testosterone and muscle mass that creates a different, physicality. But intellectually, there's no difference, and that's what really matters, right? Here, it's the physical rigors that are being questioned, and the court says, look, there could be a woman out there that, or many women, right? You can't have a number that could actually meet the standard. You can't make the assumption that they won't be able to meet the standard. That's discriminatory. Okay, now what about valid discrimination? Valid discrimination. There are a couple of cases here. Under equal protection, now there's discriminatory intent, but the court has upheld them. The first is Michael M. versus Superior Court. Law punishing males but not females for statutory rape, sexual intercourse with a minor, right? Classification was found to be substantially related to important interest of preventing pregnancy of minors. Okay, we'll lay out all three of them. We'll discuss them. Male-only draft registration. This is Roscoe versus Goldberg in 1981. Both these cases are 1981. The previous one, Michael M. in this. Classification was found to be substantially related to important interests of preparing combat troops. And finally, a law genuine automatic United States citizenship to non-marital children born abroad to American mother, by requiring American fathers of children born abroad to take specific steps to establish paternity in order to make such children United States citizens. We know who the mother is. We don't know who the father is. And so there's discrimination there. The father has to demonstrate that, that he is the actual father of the child. The mother, there are records. We know she gave birth. We know that she's the mother. It's different here. So the court says, okay, we're going to allow that kind of discrimination. In the first instance, in Michael M., statutory rape is as it is defined in the statute, which is sexual intercourse with a minor. The court said, listen, it's substantially related to an important government interest. So we're going to allow that discrimination. It makes constitutional sense to do that. Male-only draft registration, however, they're arguing, well, look, it's important for the preparing of troops. Men and women, if the argument is made that, in some way, side-by-side preparing is problematic, the courts are going to yield to that a bit. And then the child being born aboard. The next, and we'll stop after this, but the next classification, which I just want to sort of touch on, is this idea of legitimacy classification. Marital and non-marital children are also reviewed under the intermediate scrutiny standard. Such classifications must be substantially related to an important government objective. That's Clark versus Jeddah. That goes back to 1988. Now look, is there a value in distinguishing between children that were born to parents who are married as opposed to being born to parents who are not married, right? So it must be substantially related to an important governmental objective, right? So drawing, some sort of, distinction between marital and non-marital children, right, is intermediate scrutiny. And the court, there's a few things here. There's no punitive purpose in doing this. Court examines the classification based on illegitimacy. It gives greater attention to the purpose behind the distinction. It will not uphold discriminatory legislative intent to punish the offspring of illicit relationships. In other words, the court looks at the facts. And if they believe the law is just punishing people for not being married and having children, it's going to strike it down. If there's some other rationale for it, the court will entertain that, right? All right. I'm not going to go into immigration preference or that sort of thing. And I'm going to leave other classifications for the next lecture. We're still in equal protection, and we're going to try and move along and wrap that up as best we can because we get to midterm, and it will cover all these materials. Okay, second lecture is coming up.